A two-day conference on international tax was held recently in New Delhi. Organized by PhD Chamber of Commerce and Industry, the conference aimed to provide a platform for senior government officials, eminent tax experts, professionals and representatives of embassies to get together to share and exchange views on global tax issues. The conference started with a welcome note by Alok B. Sriram, President of PhD Chamber of Commerce and Industry, where he set the tone of the conference by highlighting the importance of an effective tax system in India.
The PhD Chamber has been organizing this conference with the objective of promoting an informal dialogue on significant issues in international taxation and at the same time promoting cross-border trade. Friends, India is one of the fastest growing economies in the world. Taxation policies play an integral role in the overall economic development of a country. An effective tax system plays an important role to promote investment in any country as well as outbound investment by helping the companies to be more competitive in the global arena. A simple, transparent and non-adversarial tax regime bereft of complexities and ambiguities would go a long way to strengthen business sentiment and restore faith of foreign investors in the India growth story. There is a need to reduce litigation to promote the investor sentiments and at the same time promote the ease of doing business within India. Finally, I urge all of you to give more suggestions on how investment can be made in India, especially looking at the fact that our other competitive countries are having their own set of problems, and what are the facts which we need to change for ease of doing business as asked for by the Prime Minister himself. I trust the conference would be useful and fruitful to the participants and the tax department. Thank you.
Ladies and gentlemen, the Government of India has taken steps to improve the tax system with an aim to make India a preferred destination for trade and commerce. This point was further elaborated by Anil K. Chopra, Chairman, Direct Tax Committee, PhD Chamber of Commerce and Industry, who stressed on the point that India must be competitive in terms of tax rates.
Several steps have been taken by this government with a vision towards making India a preferred destination, to make India competitive. Positive measures include assurances that we will not have retrospective amendments, clarifications on indirect transfer, reduction in tax rates on royalty and FTS, extension of concessional rate of interest under 194 LD, merely the presence of a fund manager not making the eligible fund a resident of India, reduction, and this is a big one, it's simple but basic, in corporate tax rates from 30 to 25%, exemption from MAT at least prospectively to foreign portfolio investors, and deferring of GAR for 2 years. However, there continue to be challenges and concerns for foreign taxpayers. These include certain difficulties when sometimes or more there are overpitched assessments, concerns about unwarranted TDS prosecution, transfer pricing, substantial litigation, and there is a need for creating efficiencies in processes. The announcement on MAT for prior periods for FPIs is awaited. Tax rates for foreign companies at 40%, we do believe, needs to be reduced and addressed. As countries move towards creating a more competitive tax environment, an environment which encourages innovation, investment, jobs, governments must agree on what is acceptable and what is unacceptable competitive practice. All nations compete for their fair share, so does India, and clearly we must do so. Certainty, clarity, dispute resolution, good governance, justice, fair play are appreciated objectives of a good tax system. We believe, and I sincerely believe this, that the government is seized of this and is making real efforts in this direction. Thank you very much for being with us.
To make India a preferred trade destination, the government has envisaged certain steps to create a conducive and enabling environment for all stakeholders. This assurance came from Shakti Kanta Das, Revenue Secretary, Ministry of Finance, who elaborated on the economic policies of the government and advocated the need for finding the right balance between taxation interests of the government and ease of doing business for industry.
You are very well aware that when it comes to international taxation, the first priority of every country is to protect its taxation turf. In the zeal or in search for protecting your taxation turf, one should not make things so cumbersome or so difficult that there is a flight of investment or there is a flight of business from one country to other countries. So finding the right balance between the taxation interests, the revenue interests of the government in matters of international taxation, and on the one hand, and on the other hand, providing an enabling taxation framework and environment where it becomes that much more easy to do your business, to invest, to draw, to sort of run your business becomes easier. The whole focus of the government's taxation policy or economic policy is on unleashing forces of growth. The focus is on job creation. The focus is on attracting more investment, providing a business-friendly and enabling environment. Now, internationally, in every country, we have tax disputes. What is very important is what mechanism the tax structure of the country provides for dispute resolution. The developing countries, including India, feel that arbitration cannot be the best method for dispute resolution. Taxation is a sovereign function of every government. It is therefore desirable that when there is a tax issue, it's better that the two governments sit together and resolve the matter through the MAP, through the mutual agreement procedure, rather than involving a third party who arbitrates. Thank you very much once again for inviting me to be here.
Base erosion and profit sharing, or BEPS, is now a global phenomena that has become a point of concern for many. Anita Kapoor, chairperson of Central Board of Direct Taxes, touched upon the issue and further revealed her concerns on BEPS.
Tax administrations across the world recognize that global businesses have raised issues of base erosion, profit shifting. So here I would like to underline that there is a profit known to the tax administration, but it is shifting, seeking a tax jurisdiction where to show those profits, taking into consideration the tax rates so that the tax cost is minimized. For global businesses, BEPS is an area of concern. Tax administrators are apprehensive, businesses are apprehensive. But I think once there's a convergence of what the right tax policy is, what the TT philosophy is going to be, I think life is going to be easy. But I'm more concerned, apart from these international developments on BEPS, also about base erosion and profit secreting. There's another BEPS, the domestic BEPS. We live in a country where the government requires resources to provide public goods. And we live in a country where we have adopted values in our constitution to give equal opportunities to provide equity. And if my tax administration is not able to give a fair treatment to all the taxpayers, not able to collect taxes from people which are legitimately due, and to enforce tax compliance from people who don't have resources to minimize their tax cost by certain undesirable practices, then the tax administration is also failing in upholding the values of the Constitution. So when we talk of trying to see that our officers are fair to every taxpayer, we also expect from the enterprises, from the consultants, to contribute their might in making their affairs as less complex as it is possible given the state of law that we currently have. Thank you.
The conference focused on the point that tax policies, growth and competitiveness are the same side of the coin. This was driven home by the Vice President of Income Tax Appellate Committee, G.C. Gupta. In his address, he pointed out the other side of the coin which needs as much attention.
All that is said and would be discussed in these 2 days is only one side of the coin. The other side of the coin is lost sight of. One side of the coin which is being discussed is regarding the various provisions, clarity, it should be like this, that, and definitely it is very, very important. But the other side of the coin is how to minimize the litigation, and if at all the litigation starts, how to come out of it. I am pained to say the position today, which may not be well appreciated by the authorities, is total chaos. In Delhi bench alone, we have more than 1200 cases pertaining to transfer pricing. International taxation is different. That is being distributed amongst all the benches working here. 8-9 benches are functioning. Apart from that, 1200 cases, and disposal is very few. I am not blaming any one party, the department or the SSCs, but we have to all sit together, find a way. We are all equally important and equally responsible for this state of affairs. Thank you.
The conference set aside a complete panel discussion on the topic of black money. Some of the most prominent tax experts, along with government officials, discussed the issue of undisclosed foreign income and Assets and Imposition of Tax Act 2015.
Black Money Act applies to an assessee who is a resident and ordinary resident. So effectively the act is applicable only on the residents. But then it says any other person who is deemed to be in default under the act. So effectively a non-resident can also make a declaration as far as this part is concerned, and therefore according to me in this definition when they talk about if you are in default, any person who is in default, maybe they wanted to capture such a situation. Second is undisclosed foreign income. Includes income from source located outside India, which is not disclosed under the applicable tax returns, or for which the tax return should have been filed but was not filed. So effectively this is very clear. The important aspect in this particular section, which is section 212, is they are talking about an income, the income which would have been chargeable to tax in India. If that income is not chargeable to tax in India, then certainly you don't fall under this undisclosed assets. And I think the intention is clear that when I talk about chargeability, you cannot ignore the double taxation treaties. So the treaties have to be considered before you take a call whether the income is chargeable to tax in India or not. And lastly, undisclosed assets located outside India means assets including financial, interest in the equity, located outside India, held by the assessee in his name or where he is a beneficial owner. And the word is not or but and. Asset has no explanation about the source of income in such assets. That is a one category. And the second one is explanation given by the assessee is unsatisfactory in the opinion of revenue. So certainly there is a subjectivity. There are no clear guidelines on which basis those things would be determined, what kind of evidence would be required, where I think some more clarity would be, and where I'm saying genuinely, because we have been interacting with the people, there are certain apprehensions because of this clause, and I'm not saying this clause is not right, but just because wide powers are given without any clear guidelines, there is a doubt. I think with this I would like to close down. Thank you very much.
The first point is that we want people to comply. This is a last opportunity, a window for compliance, and people must comply. We believe that there are some people who are hesitating to comply because they need some clarifications. There are some doubts on the real meaning and interpretation of the provisions. So these clarifications are needed. There are some hardships. Those also need to be removed, and the government has the power to remove hardships. We have been gratified that Revenue Secretary has said that clarifications, FAQs are further coming to remove doubts, and this is very welcome. One of the concerns of the taxpayer is, will his information be kept confidential? The Revenue Secretary has also assured that the information will be kept confidential. So this confidentiality will again promote compliance. On what are the sort of issues and doubts that are there, and concerns that are there, or hardships that are there, there is no time barring or limitation as to what is the period up to which they can ask questions or what needs to be disclosed. Now, generally in any law, there is some reasonable time period. One cannot comply with matters relating to 20, 30 years old. Normal tax limitation is 6 years, foreign asset 16 years. How can somebody comply beyond that? And supposing a person was doing something wrong and the government is giving him a chance to come clean, then when he was doing wrong, he's not going to keep records which are 20 years old, 30 years old. So how should he comply? The second thing is, the evasion has to be based on income evasion in India from tax. Now, this income evasion is different to the value of an asset. So clearly, logically, what does not relate to income evasion or the consequences of that has to be kept in mind. They have said bank account balance less than 5 lakhs will not be considered. We would urge that assets of less than 5 lakhs should not be considered. There are so many large, high-value assessees to look at. Innocent, inadvertent mistakes made by somebody for small sums of money should not result in prosecution or adverse consequences. So exclude a sum, say 5 lakhs. 5 lakh asset excluded, just like 5 lakhs bank balance was excluded. There are aspects of residency. Sometimes there are issues of how to arrive at the residency of a person. Or there is a debate as to, is a person resident of country A or country B. And there are tiebreaker tests in treaties between nations. Now, are these treaties also to be used for deciding residence? Because it says Income Tax Act will apply. Treaties apply under Income Tax Act. So just like in normal act, treaty resident issues would come into play for or against an assessee. It should be the same for undisclosed foreign income act also. The solution is that the government must consider the hardships. They must consider the concerns of taxpayers and of the citizen, and they must try and remove these hardships and try to address these concerns by removing hardships. And we do hope that something will be forthcoming and coming soon, because compliance dates is shortly approaching.
The conference promoted a dialogue on important issues of international taxation and analyzed and debated on Indian tax laws for a more effective and efficient tax regime that would facilitate and promote foreign direct investment and cross-border trade. In the final session on vision from tax perspective to make India a preferred destination, representatives of Japan and America put forward their concerns. Here is what Mukesh Butani of BMR Legal said on the topic.
I think this whole topic about visioning from a tax perspective to make India a preferred destination can be looked at it from two standpoints. One, if you look at it positively, as Anil rightly pointed out, some steps have been taken, in my view, baby steps, but a lot still needs to be done for us to be desired to be a preferred destination, purely from a tax policy standpoint. And a sarcastic way of looking at it would be saying that really nothing is going to happen, things are just going to go from bad to worse. I don't believe in that philosophy. I think that we are on a path where things will improve in the future. What are the basic 3 principles for any sensible tax policy? The 3 C's: certainty, clarity, and consistency. And I think if there is any tax policy which doesn't meet any of these criteria, then I don't think we should pursue with that policy. I think on the dispute resolution, again, wide-ranging recommendations were made. Why do we actually have disputes? Forget about trying to deal with reviewing the administrative aspects when you have dispute. Let's talk about how do you avoid disputes. Why don't we talk about that? I think a lot needs to be done on tax administration. I think our administration needs to realize that taxpayers are their clients, are their customers. I think a fair bit of recommendations on the alternate dispute resolution, introduction of arbitration conciliation negotiation. Mr. Das spoke yesterday, and I know the view that the administration is taking a complete no-no on arbitration and reconciliation. I would like to believe that if India needs to have a meaningful place in the global arena, not just for foreign companies doing business in India, but also for business that Indian companies will do outside India, it's in the interest of both this that India should embrace arbitration, India should consider, maybe in some limited form. So I have a different view than what the Revenue Secretary expressed yesterday on arbitration. So that's really what I had, Anil. I just hoped I'd stick to the timing that you gave me. Thanks.
In my intervention, I just want to stress 3 points. One, just as Mukesh mentioned, Japanese business regards India as one of the very promising countries. And the second point is that many Japanese companies regard India's tax system as complicated and see it as a challenge. And the third point is that Japan and India are strengthening the bilateral economic relationship. Many Japanese companies see India as a very promising country, but at the same time, they regard tax issues in India as a challenge. Improvement of the business environment in India, including tax issues, is critical to achieving this ambitious target. In this light, I look forward to working with my Indian friends to improve the business environment in India, including tax issues. And I would like to reiterate my belief that its improvement will further enhance attractiveness of India as a preferred destination for Japanese investments, and certainly lead to strengthening the India-Japan bilateral economic relationship. Thank you.
Overall, I think that we can say that the U.S.-India relationship is growing stronger and stronger. Getting down into the taxation, just some observations. As has been stated before, that ranking of the ease of doing business on that World Bank ranking is something that I think is on all of our collective minds of how can we get better. And I think some excellent points have been made at this conference about that. And I would support those. Along with those lines, I wanted to point out just one thing about bankruptcy reform. That I think is something that we can see development in coming months. And I think with the bankruptcy reform proposals that are being written and will be proposed to the Parliament, that will, of course, tie into the ease of doing business and to support the development of our commercial relationship. Thank you very much.